Welcome back, folks. This is Joint Justice Oversight Committee. It's our afternoon meeting on September 28th. And we are going to start off our afternoon meeting with talking about our community justice centers. And as part of our directive is that we need to look at strategies for ensuring geographic consistency and equity for our restorative justice programs and services. And we need to recommend any changes to streamline the restorative justice programming and services that coordinate the roles, responsibilities, and funding of DOC, the Attorney General's Office, Department of Children and Family Services, and any other entity that administers restorative justice programming and services in the state. And we have the ability to submit any proposed legislation. So it's a big lift, a big directive for us to do. So we have with us today some of the directors, executive directors, and directors of some of our community justice centers. We did schedule Jill Evans, who is the executive director of the Essex Community Justice Center. She's unable to attend today. She's not feeling well. So we have three directors here. Rachel Jolly from the Burlington Community Justice Center, Mel Motel from the Brattleboro Justice Center, Community Justice Center, and Heather Hobart, Director of the Lemoyle. I blew it. I always do. Lemoyle Restorative Center. So I would ask the three folks to come up. We do have three chairs right there. I think this would be good to open it up for you folks to give us how your centers operate, your funding, what programs you are. But I'd like to also encourage us to enter into a dialogue with all of us to really try to get our handle around the justice centers and get a better understanding. And so we're opening it up to you folks. And if you could just go down the line, introduce yourselves, and then we'll start off with you three. Welcome.
Well, thank you very much, Chair Emmons, for having us. For the record, my name is Heather Hobart. I'm the Executive Director of Lemoyle Restorative Center. And I just have to say, it's really nice for me to be back in this building. As I walked up the steps, I was like, what feels so good about this today? Oh, it's the first time I've been live. So nice to be here.
Great. And my name is Mel Motel. I'm the director of the Brattleboro Community Justice Center down in Windham County. And as we'll get into later, I actually co-direct our restorative justice department. Glad to be here.
Hi, everyone. My name is Rachel Jolly. I'm the director at the Burlington Community Justice Center.
So we tried to get a geographic coverage with the directors here, and I hope we achieved that.
Absolutely. We would like to, we know that Chair Emmons asked some really specific questions of each of us, and we're going to answer them sort of down the line in order. And then we're happy to take questions, if possible, at the end of our brief presentation, just to make sure that we all sort of, you can hear from each of us, if possible. Again, my name is Heather Hobart. I've been with LRC, as we call it, in Lemoyle since 1999. So I've been around for a lot of the changes in the justice system throughout Vermont. I just want to quickly orient you to understand that we are a community-based nonprofit organization at LRC. We've been around for 42 years and are embedded in the community that we're in. Our mission is to uphold the dignity and resilience of individuals and families through RJ principles and programs. We serve between 700 and 800 people a year. We have 19 employees, 30 volunteers, and in general, we're working to keep people out of the justice system, and if they are involved in the justice system, to keep them from going further. We also do work that you might not know about related to school engagement, so people attending school, children with a history of abuse or neglect, lack of community connections, sort of prevention work, as we call it in the field. We are the only restorative justice organization in Lamoille and in other counties, as you all know. There are multiple organizations in Lamoille. It's just us. We hold the contracts for DCF, the AGO and DOC to do the RJ work. If I'm speaking in too many acronyms, give me the time out. I'm just trying to be brief and quick. And I'm going to talk in a minute. I'm going to hand around a pie chart for you to be able to see to answer your question, Chair Emmons, about our revenue sources, so that you can have a look at that. We're overseen by a 7-person board of directors. And just, again, for orientation's sake, the three of us are here and we really wish Jill could have joined us. She's been part of the planning with us. It's a recently formed RJ work group that consists of the three, Mel, myself, Ellen Wicklund from White River, Jill are the three, Jill Evans from the Essex Community Justice Center, and then Derek Miadovnik from DOC, Lindy Boudreau from DCF, and Willa Farrell from the Attorney General's office. So we've been anticipating your questions and wanted to sort of be available to answer them. So that's how we're here. We worked hard at being able to make recommendations collectively, and also wanted to create opportunities for us to speak personally from our own experience. So again, we'll work to answer questions and then also speak sort of personally. So I want to just highlight we have two specific work group recommendations that we'd like to make. One is that you consider prosecutorial discretion related to geographic equity. We've seen through the testimony that that's really been a focus of yours and very much appreciate that. And we believe that the best way to tackle the geographic equity issue is to focus on prosecutorial discretion. I'm going to tell a couple stories, actually 4 really quick ones, to highlight the prosecutorial discretion issue. One is related to a 17-year-old youth who was issued a citation for underage drinking at a graduation party. Her ticket was sent to that county's court diversion program. She was given the opportunity to engage in youth substance awareness safety program. Every county has that program, and there are common guidelines and procedures that guide that work. A 35-year-old man was released from incarceration after 15 years serving a sentence for sexual assault. He was referred to a local justice center for support with reentry navigation, to really get him set up with work, employment, and social services that he might need. Reentry navigation is also provided in every county in the state. And that work has core principles, guidelines, and practices that guide that work. A 14-year-old struggling to attend school was recently cited for a simple assault charge and a retail theft charge. He was dealing with anger management issues and making good decisions. He was placed on probation. And that's with youth probation, as you all know, that's a DCF connection. He was referred to Barge. He had a risk screening done, which is a YAZI, which I know you've all talked about and heard about. He went to a panel. There is a Barge program in every part of the state, and every Barge program also follows common programmatic guideline and practices. So that gives you a sense of sort of the equity issue. Now, I want to talk quickly about a 60-year-old woman, which we're going to talk more about. 60-year-old, 60, yeah.
Sounded like 6.
6-year-old woman, no, who was charged with a retail theft for walking out of Hannaford's, the self-checkout line without paying for the items in her cart, which totaled $65. She has no prior charges. She is referred to the county's court diversion program. Again, there is one court diversion program in every county in the state. And I tell you those stories so that you can imagine that every program might be housed in different organizations, but each of those programs is consistent, regardless of which entity they're sitting in. And you can expect that work to look very similar because of our guidelines, practices, and procedures across program to program. The equity issue that I really want to highlight here is that with this 6-year-old woman who stole from Hannaford's, the prosecutorial discretion issue could have her going any which way. In that example, she went to court diversion, right? She could also be charged with in criminal court for the offense and given a fine only. She could be charged for the offense and sentenced to probation with a condition to engage in an RJ panel, which is called reparative probation. She could be charged in criminal court and given a deferred sentence with a direct referral. She could be offered court diversion where her record is expunged, what I gave. She could be offered pre-charge where her case is dismissed if successful. She could have her charges dismissed with no program referral at all. The way those decisions are made is by the prosecutor, not by the programs that receive her. So I think that highlights the real crux of the issue here as we see it, in that it's prosecutorial decision-making that's really guiding which door that 6-year-old who walked out of Hannaford's enters.
Yeah, go ahead, John.
Very quickly, you're highlighting that as a problem. Is the avenue you see that we could be taking to move that decision-making process to the programs that you're talking about, or that we would direct the prosecutors via statute?
I appreciate that prosecutors are making on any given day many decisions that affect people's lives. I don't at all see that as a problem. The reason we highlight that is that it really is the place where I think some of the question around equity should be focused. And I bring it up, we bring it up really as a way to ask you to focus more on it and less on the funding structures per se, to really help support the people that are getting those services and the people that are being affected by them as best as possible.
But I think the issue that we struggle with, there's a lot of doors there that could be opened up. So that 60-year-old person that went through the checkout line at Hannaford's in one county with a prosecutor could be sent to diversion. In another county, it might be ended up deeper into the criminal justice system. And that's the issue that we have, is that it's not the same justice county to county. And I'm wondering if there's too many doors.
I think to answer that question, Chair Emmons, just really quickly, and then and Senator Baruth, I think the place to start, knowing that there's no way to nor should we necessarily be trying to address the different options that a prosecutor has. We see it as the pre-charge door that I mentioned is something that really could get attention. And is our second recommendation from this work group is to focus specifically on reviewing pre-charge and court diversion policies, practices, and statutory frameworks, so that we can really, we collectively, you all, can get a sense of what that picture looks like. To your question, Chair Emmons, how many people are going court diversion versus pre-charge and why? I think having some data around that and also looking at some of the statutory frameworks around pre-charge would be really helpful. And it's something that our group has decided collectively would be a recommendation we would make.
It means that you would collect that data on our behalf, or how are you suggesting that that data be collected? Because it is a question that we have asked around this table.
I don't know. I'm sure we could be helpful with
figure it
that,
out.
and I don't think we've gotten that far yet, but we're
Yeah.
happy to entertain that
Okay, thank you.
concept, yeah.
So Teresa, and then Dick.
My impression was, and I felt like it was clarified with the information that we've gotten on these charts and then further from your testimony, Heather, that it's not about the lack of consistent availability of all of these services across the entire state. It's how the decisions are made when to access what service, or what door does a person end up going through? And, so that's a sort of a whole different question about geographic justice. I feel like in one sense, we've heard enough testimony to understand that there is access to all of the services, but how you get access to them is really dependent upon that one door. Well, there might be multiple doors, but really dependent upon that, as you're saying, the prosecutorial judgment there. And so that's an important question for us to feel, one, at least comfortable with, that, all the services are available statewide, but enables us to maybe focus a bit on are these services being accessed equitably statewide.
I will say, I will also say that the juvenile system uses the YASI, the assessment tool, which is very helpful in determining which door young people should go through. And we've learned so much in the justice system about across the country about how helpful those assessments can be to help guide those decisions.
And I know you're going to get to funding in a little bit, so I've taken a peek at your
Yeah, I'm going to
chart.
fast forward through.
That's okay. Yeah, I have
Just one quick
questions when we
question.
get there.
So the number of folks who are going through each of the programs is something that we would have access through from you. So that would be an indication of that relationship to the budget.
Yes.
So key.
And referral source, not just numbers, but the referral source.
Yes, thank you, yeah.
So we have another question.
Well, I'm just going to quote from my notes from June 7th. Should judges have the ability to send people to diversion? Seems like if you're talking about equal access, it's one way to, so if a judge gets this woman and she's charged with one of the crimes where you've just been in another county or she's just been in another county where this woman is sent to diversion. Could the judge override the prosecutor and say, I'm sending this case to jury? That's the question. That's one way to at least deal with the outliers.
Or create a priority for diversion. That's
Pardon?
I said, or create a priority for diversion. So in other words, that prosecutorial discretion, you say, okay, you go to diversion unless, and then there's.
I just didn't put that down in my notes.
That's what you meant. Yeah, I thought so, Senator.
The note was a little brief, but
So you're going to create another off-ramp, potential off-ramp for judges to be able to use.
Can we close another ramp?
Yeah, close the other ramp or leave both ramps.
well, I mean, it would take care of, either way.
Yeah.
Would take care of the outlier, where if in Chittenden County, I write a bad check for $50 and they just ignore it. But in Bennington County, I go to jail.
Right,
There should be
right. I mean, the
I
way,
shouldn't say ignore, excuse me, public.
I know. They treat it differently.
They charge and,
Yeah. But I mean, if, all of the things that Heather just talked about, enumerate all the different options that there are for the prosecutor to do or not do. If we created a priority for one, it's sort of like, if you can meet this, if you meet the criteria for this, then this is the one that you should use. And if you don't, then you have options of these other, I mean, it all depends on what policy we want to create. If we're creating a policy that, that wants to prioritize diversion, then it seems like we would have the law prioritize diversion.
We'll have further discussion.
Yes.
Let's keep going with the testimony. You see how complicated it gets.
Let's see, how much to fast forward? I want to make sure that Mel and Rachel have time. Just looking at, making sure that we, like I mentioned, the pre-charge and diversion look and sort of where there are places, for example, where court diversion referrals are up, are pre-charge referrals down, and vice versa. Sort of what does that all look like? I would just for full disclosure like to say that we in Lamoille don't offer pre-charge programming for two reasons. One is I have concerns about rights of participants and concerns about unexpunged cases of those participants in pre-charge. And as importantly, I feel very strongly that Department of Corrections funding should support adult participants specifically, not youth, and that it should happen at these intercepts down the line, 3 and 4, on the sequential intercept model, as I see it. And again, that's sort of a personal reflection that I just want to make. I'm just going to wrap up by saying that I don't believe that merged funding would make our organization more efficient. I do think that common contract budget templates, reporting forms, and a core set of common outcome metrics would make us more efficient. It would also be more helpful for you all, I think, to keep track of data as an example. We're doing a really good job of data collection. And I know that there will be certain places that we might not be able to collect 100% of common data, but some core set would be great. And just again, to speak to the varied funding streams at our nonprofit, and this is a pie chart of our funding that I'll hand around. I actually see varied funding as a positive. It helps us mitigate issues when funding is increased and decreased. We recently had a funding challenge with the Department for Children and Families, which I know Representative Squirrel is aware, for our program for kids of incarcerated parents, and maybe others of you also are aware. That required us to close the program and lay staff off. It was a really hard time for us. The loss of that revenue was very significant, but because we have other revenue sources, we're still able to keep our doors open. So, just a varied funding stream I find incredibly helpful. And again, this is one more personal pitch. This is not the collective groups. We don't have consensus on this necessarily. I feel strongly that our organization having one sort of oversight by one of us and not multiple within a town or county serves our rural model better. And I'm just going to give you a couple examples. A 55-year-old woman who receives support from Department of Corrections for reentering after incarceration. She needs her license. She's walked down the hall in our office to talk with the person overseeing the driving with license suspended program. A family who was referred to diversion for an altercation. The daughter is in diversion. The father got reparative probation because he has prior convictions, and the judge really wanted him to come talk with a panel. They're both seen by different people in our office, and the victim is served by our victim liaison at LRC. So I think it just gives a more holistic way of looking at that family and supporting them sort of in one place. I do understand that that model might not apply in all communities, and I also support allowing communities to make their own decisions about how to do that best. I'm sorry I took up so much air, and I'll pass it along to Mel.
Thank you, Heather. Yeah, thank you for laying a foundation for us to probably reiterate some of what you've said, but hopefully not be too redundant because I know we have limited time. So my name is Mel Motel. I'm the director of the Brattleboro Community Justice Center, and I hope what I'm about to share about our organizational makeup doesn't make things more confusing, but I do think it's helpful for you all to have an idea of the different ways that CJC funding is stewarded throughout the state. So I actually co-direct the Restorative Justice Department at our agency with another co-director. I oversee the Department of Corrections funding, the CJC grant, and my co-director oversees the AGO RG funding and the DCF RJ funding. If you look at the colorful chart that Jill Evans sent, you will see sort of how that's represented. From 2003 to 2021, the Brattleboro Community Justice Center was housed at the town of Brattleboro. So we were a municipal entity. A year ago, however, the BCJC staff, 3 of us, moved from the town to merging with the restorative justice programs at Youth Services of Windham County, thus bringing all state-funded restorative justice programs under one roof. That's at Youth Services, even though we serve people of all ages. To confuse you further, the nonprofit is Youth Services with a 50-year history of serving people of all ages in the community and 25 staff and years of experience running AGO and DCF funded restorative justice programs. Since you've asked for testimony on CJCs specifically, I know it's hard to tease out because there's 3 different sources and we're all kind of one-stop shops here. I am going to share about our CJC programs specifically. Since bringing all RJ programs together under one roof last year, the CJC's scope hasn't changed significantly. The CJC grant from the DOC continues to support all the DOC programs and services noted on this table that you've received from Willa, which I think is a really clear table that shows that yes, all of the funding sources provide funding to programs and services in all counties across the sequential intercept model. So the CJC, that is DOC programs, provide dispute resolution at the community level, restorative pre-charge, which we've talked about a little bit, direct from law enforcement or the state's attorney, restorative panels for people who have pled guilty but are offered a restorative alternative, and reentry services such as COSAs. But now that we are all under one roof, the BCJC is now part of a 9-person restorative justice department that is co-led by me and a co-director. Everything on that table is now covered by our department. So we're a one-stop shop, we do it all. We also receive additional funding. I don't have a nice chart today, but we do receive additional funding outside of the 3 state sources to craft programs that are specific to the needs of our community, which I think is really important. The state funding is important. It's also important for us to have flexibility to seek additional funding to really meet our community needs, like in schools, in neighborhoods, in our communities. And furthermore, our RJ department is part of an agency that provides an array of other programs outside of RJ. Kind of like Heather, funded by a variety of funding sources, federal money, individual donations, grants, et cetera. And the way that we work is kind of similar to the way that Heather described. Now we are able to do the warm handoff in the hallway for someone who comes in for one program and might need the clinical services of our clinical department. It works really well for our community. So I want to note that the choice to merge all RJ programs was a local decision that came from years of conversation and consideration for our local needs. I regret that Jill's not able to be here today from the Essex Community Justice Center because her situation is different. And I feel like we're all 3 people saying, you know, this really works for us to have everything under one roof. But I understand that might not be the right path necessarily for all locations. So there was a question asked of us ahead of time. Who do we answer to? The CJC programs, again, I'm focusing on CJC, are accountable to our funders, the DOC. We're also accountable to our broader agency and board, much like Heather. Our additional funders, community partners, including those who refer folks to us. And importantly, we're accountable to our community, to the people who live in our community. I think that is, I like to put that in the room as we talk about funding. It's about people. So I want to just underscore some of the recommendations that Heather shared, and I won't go into detail because we've already gone a little bit into it and we'll do more. About the geographic equity question, I agree, as you know, that as you can see, all places in the state receive funding from all 3 state sources. It's a matter of discretion in some cases about who gets sent to what program. This may result in geographic inequity, such as high numbers of referrals, and some it's a pre-charge in some places and others none. Pre-charge and court diversion policies and practices, I agree with Heather, need to be reviewed. And how we do that, let's figure that out. But I believe strongly that they need to be reviewed. And I think they also need to be reviewed with an eye to racial and economic equity. I think it's really important. We're talking about geographic equity. Is the person in Bennington County getting the same thing that the person in Windham County is getting? But also, are there people of color? Are there people of different classes being referred to some places and not others? We need to be looking at that potential bias as we explore that. So I just want to put that on the table. I agree with Heather that multiple state funding sources or diversified funding streams in general help to ensure stronger organizations for some of the reasons that Heather named. And I won't add more details about that. And I would like to add my personal recommendation that also with an eye to racial and economic equity, that as you explore this with us and beyond, that people and organizations that are directly impacted by the criminal justice system, adult and youth, should be part of future investigations and analyses and how state-funded RJ is working. You're talking with a really specific subgroup of people, and we're on the ground to an extent, but we are not the people directly impacted by the policies. And I think that needs to be an important piece of your exploration. So I'm going to turn it over to you all or Rachel very soon, but I do want to say thank you for inviting us here. And I just hope that we're able to move forward in a way that ensures clarity and equity, while recognizing the unique context of the communities that we're in, and to move forward in a way that prioritizes efficiency and consistency, but always keeps in mind that those impacted when we make these decisions are people. We work with people. We work with money and we work with people. And I trust us that we're, when I say us, I mean, I think it's fair to say we're here to work with you on this to try to figure these things out. So I'm happy to turn it over to Rachel.
Thanks, everybody. For the record, my name is Rachel Jolly. I'm the director at the Burlington Community Justice Center for the city of Burlington. So our CJC is one of the oldest in the state as a originally DOC funded center. It is 24 years old and is part of the city of Burlington's Community and Economic Development Office. So we are part of our municipality. Our mission is to address the roots and impacts of crimes and harm so that everybody experiences dignity, safety, and justice in the communities we serve. We are a team of 16 with about 50 volunteers. We serve over 2,000 people a year and are located in the heart of Burlington, which is easily accessed by foot, bike, or bus. We actually, for most of our history, were serving exclusively Burlingtonians and community members in Burlington. 3 years ago, we did apply for the AGO contract for diversion, for which there was a separate nonprofit called Chittenden County Court Diversion. We applied for and received that contract. So now we, for some of our programs, only serve Burlington members, but through the diversion, we are that diversion. We hold the diversion contract for Chittenden County. So we serve members of all Chittenden County as well. And as part of our city structure, I report to the director of CEDO, who reports to the mayor. And we also have a 7-member advisory board made up of community members, and which meets 6 times a year and is comprised of interested community members in the topics that we are working with. And we are also accountable to our 7 funders. We hold the contracts with DCF, AGO, and DOC, as this committee is mostly thinking about those 3 primary state-funded RJ programs. We also have other sources of funding, as Heather alluded to. We have a similar pie chart in that we really benefit from that diversity of funding. We rely on it. I feel less vulnerable having multiple sources of funding. And so while I haven't been part of this subgroup, I agree with all of the shared recommendations and kind of where we have points of agreement around that, keeping that diversified funding. I actually would advocate for more institutions to be looking more proactively, such as the Agency of Education or the Office of Racial Equity, to be a stakeholder in our work, because I do believe that restorative justice cannot be done without racial justice. You need to have it hand in hand, given the disparities in the criminal justice system. We are one of 4 agencies in Chittenden County which offer state-funded restorative responses to crime and harm. So all 4 of us, the Essex Community Justice Center, the Williston Community Justice Center, the South Burlington Community Justice Center, and us do receive Department of Corrections funding. So that's the CJC name, but that CJC name, as you know, is confusing because it has become a bookmark or a placeholder for DOC funded. But the CJC is really a center for which you can find many programs. So we have the DOC offerings in common. The Essex CJC and the Burlington CJC offer the reentry services. All 4 of our centers offer panels, and then we are, as I mentioned, diversion and barge, we hold those contracts as well. In Chittenden County, historically, and even much prior to our current state's attorney, we use pre-charge quite a bit. I really want to add my recommendation along with Heather and Mel around looking at that pre-charge. We rely on it and we think it works well in a county that does have very large volume. But even with we have written MOUs with our police departments, and in Burlington that includes many, many misdemeanors and even some felonies that can be at the officer's discretion referred to us. There's 13 police departments in Chittenden County and 12 state's attorneys or deputy attorneys and one elected state's attorney. So there comes a lot of discretion amongst all of those players too. I do think it's worth looking at urban versus rural and how pre-charge might work in a rural setting versus a more urban setting. We actually have an employee, our panel coordinator, who worked for Heather's shop for 18 years, who also didn't think that pre-charge would work there and still doesn't in Lamoille, but coming to Burlington has a different view of how pre-charge can work in Chittenden County. So it is a complex issue, and I do think it needs more codification than it has currently. So I'd add my voice to the chorus here of saying that is worth looking into. I also want to, 2 of the personal recommendations, one each by Heather and Mel, I would very much be a fan of. Heather's first recommendation about having the common contract and budget templates, common reporting forms, a core set of common outcome metrics. I don't believe that we currently measure what's most valuable to the people we serve in terms of meaningful. Yes, we can show how many referrals we get and successful completions, but we could go a lot farther in terms of measuring why what we do is so important to the state and saves the state a lot of money, as well as changing people's lives, hopefully for the better. Having a shared database that would be designed for us would be amazing, game changer, I think, for the work that you do, as well as for the funding agencies, and of course for the agencies that implement the work. And then Mel's example of really including those people who are most impacted by this work. Everything about restorative practices is about doing with, not to or for. So we can't stress enough how important it is to hear from those who have gone through our programs when contemplating changes. Thank you again for inviting us all.
For coming in. This is very helpful because you do have some recommendations of what could improve and some that you want to keep. What comes through my mind very clear is you like the flexibility of the funding sources, prevent you from some vulnerable aspects possibly, and you like the one-stop shopping, basically, where you have the CJCs, but they're offering all different programs, so it's a one-stop shopping, and you like that flexibility. Jenny.
So thank you. This has really been terrific. With all the questions that we bring, you've answered most of them. But I do have a question about your relationship with, when you have a client who comes in who has been referred, prosecutorial referral, and then the client goes through the process. And do you ever identify a case where, you know what, this is the wrong decision for this person? And how do you keep track of that? And then do you provide feedback to the legal defense for the individual or to the prosecutor or to the judiciary in any way? How does that all sort of sugar off?
To go first? Sure. Court diversion has some really specific guidance around how communication with the prosecutor and defense counsel and police officers, the arresting officers happens. And I would advocate for that similar model to be applied across all of the restorative justice options. I think it's most clear from my vantage point in the court diversion program about what we're allowed to talk about, what we're not allowed to talk about, how much feedback we give back to the prosecutor when, for example, somebody's not successful. And I think it again takes into account the rights of the participants and keeps that at the forefront all the way through, which is really important. I don't know if there's anything else that you wanted to add.
In short answer to your question, do we sometimes have questions about cases we get and why, in compared to what we might have seen in another case? Yes, we do occasionally have that. We rely on the close relationships we have with our Burlington Police Department and the state's attorney's office because we have gone back, especially I would say in times like COVID has brought about new practices, some written and some not. And so I feel like it takes the skill and experience of our staff to sometimes look at not just the affidavit, but the holistic situation. And we have sometimes gone back to question or even decline a case when we don't think it's meeting either strictly MOU formal or less formal understanding of what we can offer as a CJC in terms of restorative practice.
Do you agree with the court diversion, the concept that court diversion has the criteria established fairly well?
Yes, I feel like that's one of the more consistent way. It has a statewide, there's a manual that has every program outlined about what's in statute and how it's interpreted through the program.
Thank you.
Teresa.
Not really a question, but I noticed you each were, referring from a document. If you were able to, whatever you want to do to, finish up those documents and then submit them, that would be awesome because we do refer back to them and try not to rely too much on our memories.
Sure.
What is the role of the victim in the pre-charge? I'm clear on what the role of the victim is in other areas, but the pre-charge.
I will say for us, we operate similarly as we might with our panels that happen further on down the road where the harmed party is always reached out to. So a case comes to us, we reach out to the harmed party and if they want to connect with us, we give them options for how they might want to participate in the program. So we have the same standard or try to have the same standard for harmed party contact and participation across all of our programs.
Thank you.
So who brings the pre-charge to you? Is it law enforcement or is it the prosecution?
Police Department in Chittenden County, where we have MOUs that do direct referrals. I think historically it started with the state's attorney agreement and encouragement of either bouncing it back, like the state's attorney looking at it and saying, we think this belongs with the CJC. We're bouncing it back to the police department to refer, and sometimes now just directly referring. So because we hold the diversion contract, state's attorney can refer directly to us with diversion. So it's kind of, become one and the same, but in short answer to your question, we get those pre-charge cases directly from our PDs.
And in Windham County, it comes from either, and I don't know what the numbers are right now, but we get a fair amount directly from police and then a fair amount, the state's attorney looks at the case and says, I'm sending this to you guys. So we, have really good communication with both of those sources in order to accept those cases.
And if I could just want to step back to Senator Sears' question about the victim, what's the role? I would say too, at the Burlington CJC, there's a similar process in place, and we have victim liaisons who can do that process no matter what the referral source is. I will say the funding for that work is inconsistent in that not all of the contracts allow for dedicated victim work. And so some of our histories and opportunities that we found through additional funding might fund that work, but that is one way that where restorative practices do include the voice of the victim, those our 24 agencies are funded differently to make sure that work can be prioritized.
Thank you.
So on the pre-charge, you really need buy-in from your local law enforcement. So if you don't have buy-in from your local law enforcement, then it's kicked up to the state's attorneys. Is that fair to say?
I think it is. And just as a point of note, we hold a one-year DCF grant right now to do some RJ training for police departments across the state around what is restorative practices, what happens at the CJCs, especially as the focus from this DCF grant is youth, but about what pre-charge could look like. Again, it needs state's attorneys buy-in as well. which is important because, again, in some counties, it might not be appropriate. The state, Heather has spoken to why, and it's questionable in some ways, but you do need buy-in, which is why I think DCF put out this grant to educate law enforcement about what it actually can offer, because I do think the misnomer about RJ being a slap on the wrist or an easy pass-through is still out there, especially for many law enforcement officers.
So what if, in all your funding stream, what if your center, DOC decided you're not providing what DOC wants to provide, and they pull your funding in the next round, contract round, a grant? What happens? Say that happens, and DOC says, well, they're not really providing those services that we are really envisioning as a department, and they pull your funding in the next round. What then happens to your center and what you provide? I'm asking a what if. Not that they're going to do it, but what if?
I do think that's a really good question, and one to look at around the codification of our work. So for example, court diversion is in statute and required that work happen. The YASI assessments for youth are required by law that they happen, so that it would prevent the worst case scenario that you're talking about, Chair Emmons, where priorities within the administration shift. And I do that with, I make that recommendation around looking at statute at every intercept point very carefully, because I don't expect you to make everything in statute for us. But when I look at this sequential intercept model, there are areas where there are no guiding statutes at each end of this model. And I think that's something to just be aware of and to notice. DCF at this point could pull funding around YASI and the Attorney General's office. And again, I'm not supposing that anybody would, just saying worst case. It also couldn't happen through the Attorney General's office sponsored programs. And there is language around reparative related to DOC. So I think just thinking about it in that way is really important. And I appreciate the worst case scenario question.
My question is more administratively. You talked about, the desire for perhaps the State Department to have similar, requirements around reporting, et cetera. Do you know, has there ever been an effort among the 3 and sometimes 4, I see Dale's on your list, to try to do that? And I know different departments have different funding sources that they use for these grants. And so those funding sources, beyond might influence that. Department of Corrections is mostly state funded. So that shouldn't be an issue. But has there ever been an effort to try to do that in working in collaboration with the centers?
I know that the Secretary's office, the Agency of Human Services Secretary was looking at an integrated family services model years ago to look at some of those efficiencies. And I don't think it ever played out in the way that I dreamed it would, having done this work for a long time now, where some of the administrative efficiencies would be passed along to us. So that's my long-winded way of saying no.
I will know that one of your questions seemed to be about the collaboration between our centers and how, we do meet regularly within the silos of the funders. The DOC funded CJCs meet, the AGO funded diversion agencies meet, and the DCF barge directors meet monthly. The Fortune and County directors meet monthly. There's a variety of groups, but I think in the last year or two, there's actually been some excellent examples of all 3 funded agency, the 24 agencies coming together for some efforts such as a shared volunteer conference, a racial equity and inclusion and belonging committee that has representatives of the various groups on there. And then most recently, a Leahy-sponsored congressional earmark funded by the Justice Department, a Justice Assistance Grant, to look at to have multiple initiatives, including racial equity initiatives and training and potentially equity audits to look at our policies and practices, but also some shared data metrics so that we can at least key the funders up to if and when they decide to do something shared, that those metrics that we hopefully all share in common that would be able to tell our story to the public at large as well as internally what could improve our programs. This congressional earmark that is starting just this fiscal year and going over the next 2 years is going to allow us to hire somebody to work with us on creating those metrics to hopefully get a little bit closer.
When you talk about having a committee look at different things, and you said might be someone from each of your organizations, or do you, who else is included in that? Do you include police? Do you include state's attorneys? Are there others, DCF? Is it a more collaborative process, or is it internal to your organization?
I would say for the congressional earmark and the REIB committee, those can include the funding agencies, but not the greater network of stakeholders, SAs and law enforcement and judges, et cetera. I think there's other, like on a local level, I think we do that outreach a lot and try and keep stakeholders involved in maybe some of the more micro decisions. But on this larger level, I guess, at least from what I'm thinking, no, it's more of the funders and the 24 agencies.
Thanks.
The model that comes to my mind, and I don't know, I know this has got some hiccups, this particular model, is our turning point networks, where we have our individual turning points within our local communities, and they have their respective boards. But there's also the network that represents all the turning points, and all the executive directors are automatically a member of the network, and then they have a head person at the network. I know that they've had hiccups, and there's been some issues with some of the community turning points that don't want to be part of the network and have pulled out, and they've changed leadership over time. Is a model similar to that? Would that be helpful to the CJCs or problematic? Or a waste of time?
I don't think necessarily a waste of time to look at. I don't think any of us probably get, based on the looks I'm just receiving now, I know I wouldn't feel comfortable speaking with any certainty on anything for the group because we hadn't discussed it. But I know that at smaller levels, we're looking at, for instance, in Chittenden County, I'm really interested in the Chittenden Regional Planning Commission model of how you could have sometimes public and private partnerships working on behalf of the whole county. Since the criminal justice system is county-based, we, are in Chittenden County all under our municipalities. And so that is an interesting thing about this, idea of an umbrella network or all under one roof kind of thing. But statewide, I don't think we've gotten that far. I think as I mentioned, it's just the last couple of years where the 24 agencies are coming together for any kind of collective work. One of the things that prompted us to look collectively was after George Floyd's murder in 2020, when we were looking for some shared racial justice commitments. And that's led to some of the other work, the theme of the volunteer conference, the congressional earmark, et cetera. So I think we're just beginning to realize, especially as more of us truthfully are becoming like Mel's and my organizations in recent history became having a foot with, first we were DOC funded and then combined to be AGO and DOC funded. And so there's now 8 of the 17, I believe, 17 community justice centers that are funded by DOC. I think 8 of us are AGO funded as well. As that happens, we're starting to think in new ways and starting to look at synergies. Synergy without duplication is something that came up at a recent congressional earmark launch. How can we work together more collaboratively and with more efficiencies perhaps, but without losing some of the local flavor and differences between our various communities?
So there's a work group in place right now that was put together with the Attorney General's office, DCF, DOC and some other folks. Do you see that work group continuing?
Yeah, we've talked about continuing on.
And what would be its purpose in the long term?
I think more of what Senator Lyons was asking about in terms of working together to look at shared data collection. I know that DOC, AGO, and DCF are really interested in that as well. So that's an example of, and I think Rachel mentioned some of the other initiatives that are happening now. So I can't say we have an exact plan, but I think there is interest in continuing that work.
And I would add that there are a number of issues that came up in our collaborative conversations that didn't seem like they were a fit for this meeting, but should be explored. So I think there's a lot more work to do as a group to create more synergy and more, shared understanding of how we do our work and what some of the issues are so that we can address them.
So I'm going to ask this not to put anybody on the spot, but was some of the initiative to get the working group together because the legislative end was starting to look at the CJCs and the justice centers and restorative justice to kind of figure out how we're going to move forward, and as a result, the working group.
Absolutely.
It was as a result of the Justice Reinvestment Report and really thinking about how we could best help you all to make those decisions.
So I see this as a process that's going to continue over the next few months and into the next legislative session. That's what I'm saying. Other folks? I don't think there's an
I'm
answer.
still wondering about that woman at Hannaford's. Sometimes I go through the automatic checkout.
Forget.
Not forget, but you could miss something.
We got Senator Sears here. Does he have a prior record?
No, but,
I know.
Do you have anything at the bottom of the cart?
Bottom of the cart. Yeah.
Yeah.
So we're going to be talking about this as a committee to really figure out.
Well, there's a lot. I mean, there are
There's a
some
lot.
very discrete things here that may help.
Right,
And you're
recommendations.
working on the data collection that will give more input for further help, so. Great.
The pre-charge thing I'm intrigued by, because
Yeah.
what comes into my mind are the discussions that occurred when we did the pretrial services. And it was very clear in Burlington between, at the time, police chief was Mike Shirley with Emmett, and I can't remember his last name, doing the pre-charge, where you physically go through the charges and say, no, we're going to divert this over here. We're going to send this person over here. This person needs to go into the court system.
I remember that we had
Remember that?
this bubble chart with lines going every which way and all that. It was fairly complicated.
Yep.
But it was understandable when we got all done, but it was not easy to try
That
to.
was before my time, but it has been formalized into MOUs. All four of our Chittenden County CGCs have MOUs with the PDs to, say there's specific charges listed out that, again, still has officer discretion enabled, but can include the following as well as more. I think one of the things too that we're getting beyond with a state who's practicing restorative practices for more and more years is that another misnomer I think about RP is that it's best when low-level cases, first-time offenders, it might be best in the pre-charge world for that, but I think we're also realizing its potential for very high-impact crimes, very serious crimes, where victims have huge impact and are looking for something more than punishment. And so I think that's part of realizing the potential as we look at more agencies that could be invested in this work is saying pre-charge, yes, has a lane to follow, but and many of our MOUs include the low-level crimes and first-time offenders, et cetera. But that we're looking, I think what the funding sources show is that there's a continuum of, on-ramps and off-ramps, and that could start pre-criminal justice system. Again, as our schools adopt more and more restorative practices, there's ways to use this to continue to de-escalate and keep somebody out of the system and keep them farther upstream.
Prevention is so much more cost effective, isn't it?
Exactly.
And we know how to do that while protecting people's rights too. I think that's I think about my daughter who's 15 and has friends now in Essex, although we don't live in Essex. and she could end up getting herself into trouble. She's going to love that I'm saying this here.
You have friends, you have connections.
Right. And I would want her to be able to have opportunities to not have the record followed her. I'd also want her rights protected. So I think trying to make sure that we're doing that in a way that's preventative and thoughtful.
That brings up for me to what the chair said early on. How do we know and how do we get statewide equitable community justice, have it the same opportunities in Windham County that the people in Chittenden County and the people that in Essex County had? How do we get there? And because we have 14 separate elected state's attorneys, that's very, very difficult. So I'm looking for you, Paul, and your group to come up with some sort of a answer to that question. Good luck.
They have the work group.
But you also have different attitudes in different police departments. In Bennington County, I think there's only 4 police departments, but I would say each one has a much different priority, much different attitude towards certain things. So as you go through this, you start to increase the inequities. Manchester may look at a certain crime Manchester police may look at a certain crime much differently than the Bennington police do or the Winhall police. I mean, Winhall has its own police department, but, so a little town like that looks at things much differently. So you have these problems. It just seems to me that there's a couple of things to, you want to avoid the gross disparity. The woman gets jail time for getting to check out the turkey in Lamoille County, but same person gets,
Diversion.
Pre-charge diversion, give back the turkey in Chittenden County. So you want to do that, but also the funding sources that you're relying on, it's really all state money. It's the same taxpayer. So there must be a way to at least streamline that. I don't know why you have to deal with 3 different agencies of state government.
It's all coming out of the same pot.
And 2 of them, the attorney general is separate.
Right, 2 of them are in the same
separately
agency.
elected official, but the
Right.
Department of Corrections and DCF are all under the same agency. It just seems like we could do some of that too. That's just my.
Yeah, I mean, I just see how justice centers have evolved. I mean, I was here, as Dick was back in the 90s with Commissioner Gorchak. And we had diversion back then. That was a model.
He had nice scarves.
Yes, he did. He had very nice scarves. Forgot about that. But, they came in wanting to build on the model of diversion. And that's when reparative boards were first put in place. And diversion at that time was only for juveniles. It wasn't for adults. And I remember Commissioner Gorchak from DOC, who was the commissioner then from Corrections, saying we need to repair the harm. And it's locals that need to do this. And that's why the reparative boards began on a municipal level, because that's where the harm occurred, was on the municipal level. So they had to have the peers on the reparative board to repair the harm. And then we put diversion for the adults. So gradually, all of this just built and built and built from that little piece. And that's why I think the statutes were a mess.
I can only say in Bennington, they decided the town didn't trust the state to continue funding the diversion program, so they refused it. And that's how it ended up in its own. Now the Bennington, whatever, diversion. But it was mainly that I can remember the town saying, no, this is probably a good idea, but we can't trust the state to continue to fund it. And we'll be stuck with it.
Yeah, there's a lot. And now we've moved away from this model of justice centers being connected with municipalities. We've moved away.
Anyway, I think we should look at the state one. You shouldn't have to write three different deals.
Well, I mean, I think I would challenge you to think about this a little bit, to the senator's comments about three different grants, or four if you've got Dale or if you've got some other state department. When they're individual grants or contracts that are going out and a department makes a decision, whether it's positive or not, to decide to reduce a particular grant or eliminate a particular grant. When they're not connected to those two or three other departments, they can more unilaterally make those decisions. When you're connected to, a single grant perhaps, and you have three different or four different departments funding that grant, you can't make those decisions on your own anymore. And that is, something I sort of challenge you to think about, because it ends up being a decision that impacts the whole as opposed to just impacting one grant. And that actually could be to more stability in the community.
But we don't want to use, I'm sensitive to you saying we like the flexibility that if we don't get the money from one entity, there's other revenue sources possible, or we could fill in that hole with something else.
Right.
But maybe it's such a large grant that it does you in the long run. You can't replace. So this has been helpful. We do have to move along because we have other issues here, but keep working on the work group. We'll be talking as a committee in the next couple of meetings on this.
It would be helpful to understand the county, the regional planning commission model that you were talking about. I know we have the parent-child centers that have the network model, and whether
Designated agencies.
whether that is something that would be effective.
Building more bureaucracy is the fear.
Well, it's self-funded out there.
I just
They
need
have
to
to pay
understand
dues to
whether it's
belong.
helpful or not.
So thank you for your insight. Thank you. If you could submit your testimony,
Certainly.
that would be
It was really helpful to hear from
Peggy?
people actually doing the work.
good. Thanks. Thank you.
Invitation.
for coming in today. Okay, let's quickly shift gears a little bit. We got two more items. This one is placement for violent juveniles with mental health issues. And I know with any issue,
It's
per se.
kids that are
Juvenile
violent
justice,
who need to be in a very structured setting.
Secure setting, secure and safe. Secure and safe
Secure and safe. And
and therapeutic. Who knows? So I know this has been circling around for a number of months, and I know that there was also some situations down in Bennington County. So we have with us, we have the Commissioner of Corrections and the facility director from Corrections. We also have the Commissioner from Department of Children and Family Services, as well as the Deputy Commissioner and the State's Attorney from Bennington. Do you have suggestions, Senator, on who we should start with? Because I know
well,
you're
I've
working
certainly
on
heard
this.
from the state's attorney in Bennington, who's, I think maybe you'd be a good person to start out to state the problem.
Is she with us?
I thought she was.
I thought she was too. I
I
don't
thought
see
she-
Not any of those people.
her in yet.
Oh, she's not in. I can't start with her.
And I just made sure I'm leaving the host because I have to head out. So
You have to head out, okay.
Host of the meeting.
Okay,
But I, certainly,
but Erica did.
I've had conversations with Commissioner Brown and Commissioner Demmel, as well as others.
Should we start?
But the conversation with Erica Mathis has been regarding some really difficult teenagers who they just didn't have any placement for, who were violent, acting out very violently, and also some teenagers involved in gun and drug trade. They didn't feel comfortable. They've also dealt with, because two of the programs that are dealing with some of these kids post Woodside happen to be in Bennington.
So should we start with the Commissioner of DCF?
Yeah, Commissioner's well aware of that.
Okay. So Commissioner Brown, we'll start with you and then we'll, and maybe your state's attorney will hook in
Maybe.
because she did confirm.
Sure, I'm happy to jump in and thank you for the opportunity to be here. It's good to see everyone today. With me, as you indicated, we have Deputy Commissioner Radke. We also have the Senior Advisor to the Commissioner, Katerina Lazias, and also our colleagues from the Department of Corrections are here as well. We did create a PowerPoint. I'm happy to walk the committee through it. It touches on different areas and Senator Sears, as you indicated, we've been working closely with the Bennington State's Attorney's Office and are acutely aware of some of the concerns and issues in that county. And so I can speak to those a little bit, and we touch on that in our PowerPoint on somewhat too. And so I'm happy to walk the committee through that PowerPoint just to highlight, I think, not just the impact of the closure of Woodside on our system of care, but I think some of the information we'll share today. The pandemic itself has had an impact on our overall system of care, which has really impacted not just juvenile justice kids, but other high-end kids with high needs in mental health needs, developmental disability needs, and just residential treatment needs. And the stress that the pandemic has put on our system have been quite dramatic. And Katerina, I didn't know if you want to pull up the PowerPoint.
In speaking with Mike, do the committee members want me to share my screen, or it's the same presentation that's on your website?
I know we do have it posted on our webpage, but I think it would be helpful if you could share the screen.
Will do.
Katerina, if you want to just jump to the second slide, and I'll just quickly finish up there and then move on to the third slide. As I've indicated, the pandemic has really stressed our system, and where we see that is in the staffing shortages across our residential programs. And that has been compounded, as we just touched on, by the closure of Woodside and the delay in opening up a new residential treatment facility that's secure. We have the proposal in Newberry that's currently under advisement with the environmental court on the appeal. Before the pandemic, we had 200 licensed and contracted residential beds in the state of Vermont. Right now, Katerina, if you could jump to the next slide. That's down to 154 licensed and contracted capacity, but only 97 of those beds are currently open and accessible to our youth because of staffing challenges. So that's essentially we've lost 50% of our inpatient residential capacity in this state from 2019 now due to the challenges created by the pandemic. And then on top of that, we have the challenges of not having a Woodside for the small number of youth that need that care. But that has really been where we're seeing the most stress in our system. Most youth do not need that level of care that a Woodside would provide. They need, some of our other residential programs or inpatient mental health care or some other type of service. But really where we're seeing the brunt of that is we've lost, we're at half capacity right now, which really puts stress across all of our systems of care right now. And that is compounded by, we've seen a little bit of a reduction in the number of foster parents we have available. So youth that are able to be in a community setting, but but are not able to return to their biological home, that also puts pressure on the system as well. And so, when you add those three together, it has created some challenges that we focus on every day and understand the urgency of getting our systems back up and meeting the needs of our youth. And that's something we focus on every day because we are seeing the impacts of that in like Bennington County or in other areas of the state as well. And I would just say, as I touched on, the environmental court took our appeal and the motion for summary judgment under advisement in early July. And so we hope to have a decision in the very near future that will lay the path forward for that project one way or the other. Katerina, I didn't know And then to the point that Senator Sears touched on, and we're seeing this issue primarily in our southern counties, but during the pandemic, we have seen an uptick in youth coming to Vermont from out of state, involved in some pretty serious activities. Many of them have been picked up in either Brattleboro or the Bennington area and have incurred some pretty serious charges. And they range in age from 15 to 19 to 20, where they would fall into our emerging adult. Many of them end up, due to the severity of their charges, being charged as adult and end up in the adult system. And given these youth are from out of state and have very, very little contact or connections to the state of Vermont, it does pose challenges in terms of how we can return them as quickly as possible to their support systems in their home state. One is, we need a resolution in some instances of the criminal charges, which is not a quick process. Two, challenges in placement while we're pending that have created some challenges. And, as Commissioner Demmel will indicate, some have been housed under sight and sound separation, a small number in his facilities. And then we work as quickly as possible to transition them to other secure facilities or try to return them with a support plan in place back to their home state. And that's primarily in the state of Massachusetts, where we're seeing these youth come in. For us, there are federal laws that control how we can return and need to return these youth to their home states. And so that also adds a layer of complexity as well to the situation. And so that is some of the challenges that are being experienced in Bennington County. These youth are charged with serious crimes. They certainly want them to be held accountable for their activities. And the same token, Vermont has really been shifting to a community-based system of treatment and services. And that is difficult when we have a youth or an emerging adult from out of state, where the most progress and supports that are going to be available to that youth are in that home state. And there are many barriers for us returning that youth in the short term, which just complicate the process and put further stress on our systems. And so I think that's something we want to focus on in the coming months. Are there strategies or solutions that can be implemented that focus on that area? Because these youth do require a higher level of services and sometimes a placement if there are public safety concerns. And we have seen that for sure, particularly in a couple situations in Bennington County. Katerina? And overall, we have been working behind the scenes for quite a while now to try to stabilize our system of care, just giving all the different impacts that we're seeing. We've definitely needed to rely on our own staff at the Family Services Division when we've not had a placement available or there's a delay in a placement, where we've now have several contracted places in Southern Vermont and in Central Vermont where we can staff a youth who needs services. And so we have a team of staff available that we call in to support these youth if we don't have another provider available or we're encountering a transportation issue. And sometimes youth end up needing to leave a placement on a weekend or in the middle of the night. And sometimes we have to activate our team to ensure that we're able to provide a safe environment for that youth on a very short notice. And so we've created a team that's able to do that. We've also enhanced our ability to really analyze the needs of youth, and we utilize a protocol of where we convene staff from different units of FSD to analyze the needs of the youth, the available tools that we have in the community of replacements, and what would be the best system to serve that youth at the time based on what we know about the youth and what services we have available at the time based on the limitations that we're seeing in terms of placements available. And that really includes, we want to make sure we're providing a safe environment for the youth, but we're also providing us a safe environment for our staff as well. And so those are some of the considerations that go into placement of youth. We want to ensure safety for everyone involved in that situation. We're also hoping to provide some de-escalation and self-defense training for our team, just to make sure they have additional tools. So if something does happen, and whether they're transporting a youth to a program, or we're staffing a youth, or we're waiting for a program to open up, we want to make sure our teams have all the tools at their disposal necessary to meet the needs of the youth that we're serving. I'll say that we still are experiencing some transportation related delays in our system of care. The sheriff's departments are spread incredibly thin right now and are experiencing similar staffing challenges. And so there are times where there's not a sheriff available to transport a youth to an available setting. And so sometimes we end up having to staff that youth until we can arrange transportation. So that continues to be a little bit, but I think, we have systems in place now where earlier in the pandemic, when we started to experience these delays, we learned through our experience of what tools we needed to create during the pandemic, and we have those in place now, and they're working. Katerina? Also, our programs, just given inflation and the ability to hire and maintain staff, have had a need for financial resources, and that are in the way our PNMI system operates, and its 2-year look back make it difficult for programs to access some increased rates. And so, we've been working to provide additional financial support through a process called Extraordinary Financial Relief. And as you'll see, in 22, we provided about $1.5 million to our residential providers to help stabilize, be able to pay higher wages, meet programmatic needs. And just in several months of 2020, state fiscal year 23, we're approaching $500,000 of extraordinary financial relief. We just want to make sure that providers have the tools and the resources to recruit and retain highly qualified staff, which will be critical to reopening some of our residential license capacity in the state. Also, some have needed to make capital improvements to improve their facilities and provide other supports to their staff. And so, we are working closely and talk to our providers to understand their needs and do what we're able to do to provide additional resources to those providers. And I would say also during this past winter, several of our programs reached a critical mass, and I'll be frank with you, there were days when I was worried our whole residential system of care was going to collapse. And we worked with the Secretary's Office of the Agency of Human Services, and we're able to access stabilization funding, which allowed us to provide traveling healthcare resources to several programs in the state, so that we could maintain capacity to make sure we had placements available for our youth. The good news is this is a very expensive alternative and option. And so we've been able to reduce our reliance on traveling resources, and our programs are slowly starting to rebuild and restaff with the resources and tools that we've been able to support them with. Also, to help support our staff, for certain pay grades who want to support this. They were limited in receiving cash overtime, and we've worked with the Secretary of Agency of Administration and received a waiver to that contract provision, so that we're now able to ensure all staff who our staff that worked with youth outside of hours, when we have placement challenges, are able to be compensated in cash, which to better support those staff and our youth. Also, we're trying to focus on stabilizing our foster homes. Last year in the budget that started on state fiscal year 23, we have a 5% rate increase and an increase in the amount of respite days a foster family can utilize during a quarter. So we hope that helps recruit and retain foster parents. But we're also looking to create a number of higher end stabilization foster homes that can take a little bit higher level of need of a youth who doesn't quite meet the, ongoing residential, but might be in a short-term acute crisis. And if we had some foster parents who had some increased training and ability to serve those youth. And so we are now paying an enhanced rate for up to 30 days of crisis stabilization to help support foster parents. And we're starting to see some of this bear fruit as well. And so also we're working very closely with AHS and our partners at the Department of Vermont Health Access on reforming our PNMI system, which I would agree needs reform. The pandemic has certainly taught us some lessons, and I think the PNMI process is one where we've learned a great deal, and I'm hoping that we can implement some of those lessons in PNMI reform in the coming months. Also, we are working closely with the Washington County Mental Health to provide some traveling resources to open up some additional crisis beds that they took offline in the pandemic due to staffing. And so that will provide some additional beds for youth and who are experiencing some mental health crisis. I would also say here that we were experiencing challenges during the pandemic, and this past winter, the Brattleboro retreat had to take some beds offline for adolescents just due to staffing challenges. And working with the agency of Secretary's office, we've been able to provide additional relief to the retreat. They've been able to use those resources to bring on more staffing, and they've been able to open up more adolescent inpatient treatment beds at the retreat. And we are really seeing movement in the system from those investments and those additional staffing and beds being online. We've had great success in getting DCF youth, particularly in the last couple months, quickly into inpatient treatment where those youth might have languished in emergency rooms or in one of our other settings while we were waiting for a bed to open up. And so that's a bright spot now where we're seeing some success getting youth access to that inpatient mental health where that's appropriate. And then also we've been working closely with certain sheriff's departments to enhance services and provide additional resources to support the needs in our care and custody. And that actually led to that project down in Windham County, which we'll touch on a little bit in the PowerPoint. So we are starting to see our efforts pay off, and we're starting to see improvement in our system of care, but there are certainly still significant challenges, and I will be very transparent. And one is the delay in opening up a new secure residential treatment program does put stress in our system as well. And we continue to work with our partners at the Department of Buildings and General Services to try to find an alternate location, just a facility that we could use to convert into that. And just the real estate market is incredibly tight right now, and properties that would meet our needs are few and far between, or even scarcer right now. And Commissioner Demel's here, and we've been examining whether it might be possible to utilize greater utilized space in a correctional facility, and there's certainly challenges to that approach as well. Katarina? As I indicated, we have been moving forward with the sheriff, the project with the Windham County Sheriff. There was two components to that project. There was one where it would be an upstairs unit where the Sheriff's Department would provide staffing, for a higher end youth who needed a secure placement, short-term placement while either we waited for a court date or another placement to open up. And then there would also be a program run by a community provider who we've identified and are working to finalize that. We're in the final stages of contract negotiations, and we're just waiting for some modifications to that downstairs space before we can utilize it. It needed to meet fire code. It needed a little work, and that work is moving forward right now. But so the upstairs is up and running, and we're in the final stages of the 2-bed crisis stabilization program opening up as well. And so we're close there. And I do want to point out that we are a very active partner in the governor's violence prevention task force and his 10-point safety plan. There is a DCF subcommittee to that task force that we're leading. And I would say that, one of the things we're focusing on now is a secure residential treatment placement for some of our higher end youth. And that's been identified as critical to this plan as well. And so, there'll be more to come on that in the coming months, but that work is just getting started, and we are involved in that. I just want to identify that for the committee as well.
So we do have some questions with some committee members, Ginny, and then Dick.
Thank you very much, Commissioner. This is extremely informative. The question I have relates to PNMI and the report. What's the title of that specific report that DIVA put out? Do you have that, or can you share it with us?
Yeah, I think
I got it, but I'm not sure I have
It was
it.
at the Joint Fiscal Committee last Wednesday, and
Was
it's
it?
on that web page.
Okay, I'll find
But
it.
it wasn't a very good report, in my opinion.
All right, I'll look at
It
it.
wasn't helpful. It didn't.
Well, maybe, given that comment, can you talk very briefly about what is involved in that report? Does it link at all with Dr. Dinosaur? I mean, these are Medicaid eligible kids, so they have not been adjudicated in any way. So can you just talk a little bit about that?
Yeah, so the PNMI process is really a mechanism to reimburse private non-medical institutions that serve either adults or kids. And we do utilize Medicaid for many of these programs. And so as a result of that, we, either through investment or through our 1115 waiver, we're able to do that. The PNMI process, was created many years ago, well before my time. And it certainly has always created challenges for programs in the way that they're reimbursed. And I think we all recognize that. And, and DIVA submitted a report laying forward a path to, in the coming months, to try to revamp the PNMI process. And we've been an active partner in that work and in the beginning of that work, because we've had firsthand experience, Senator. One of the components, there's not any type of inflationary factor built into the rate process itself. And so if a program is seeking a rate increase, it utilizes what's called a 2-year look back. So it looks back at your expenses at 2 years and then tries to do a projection. And that in its core right there, to me, is where we've seen the pandemic and then now the inflation really hurting our ability to support our programs because of that 2-year look back and no inflationary mechanism built into the PNMI rate system. And I'm speaking from DCS perspective and the work we do with our providers. We've been creative to work around that in the short term with extraordinary financial relief. But I think our programs need a level of certainty in terms of the process and the outcome of that process. And I'm hoping that's what we achieve in our PNMI revamp.
And I do have another question. Thank you for that. That's helpful. But my other question is with respect to the 10-point plan on violence prevention. And as I look through the plan, and I'm reminded that a few years ago, we added a chief prevention officer in the governor's, in the executive branch. And now by executive order, we have a chief violence prevention officer. And we also in the Department of Health have we have a prevention council and a director for prevention. And that as I look at the 10-point plan, the substance use disorder is isolated in that. And I haven't looked at all the 10 points, so I'm not speaking with full knowledge here. But is it all violence? So will it be domestic abuse? why do we have to segregate out violence protection prevention piece when we already have a very robust prevention program embedded in state government to cover all agencies and departments? And maybe you can't answer that because it's a question for the fifth floor, but anything you can offer would be helpful.
Well, Senator, what I can share is that we work regularly with the Chief Prevention Officer, who is currently Monica Hott, who used to be a DCF employee and then was a commissioner of the Disabilities, Aging and Independent Living Department. And so we have a very strong working relationship, and she is involved in all of these conversations, not just in the 10-point plan, but in other areas for the department, whether it's our family services division and prevention work there, keeping families together, the juvenile justice realm, housing, on the economic services side, the emergency housing program, very involved there. I think, and now we're also working with these newly created positions, and we're working in that work. We have in our subcommittee, at the DCF subcommittee, we have someone from the Department of Health and the Substance Use Disorder Unit, as well as a part of our subcommittee, because it really is all interconnected and interrelated, and any solution we move forward has to be geared toward that and addressing all areas of need.
Okay, thank you. That's probably that's probably the fourth floor, and I appreciate it very much.
The fourth floor. Dick and then Teresa.
Commissioner, and I mean this sincerely as well, for Deputy Commissioner Radke. You both impressed me a great deal over the years since you've been here. I kind of feel like a gambler here that you got dealt a hand that you didn't have a part in. And this goes for Commissioner Dummel as well. Right now, as I see it, we're faced with some real tough choices about some really difficult kids who are acting out in a very violent manner. Firearms are often used. And the female assault in Bennington involved a firearm, although she didn't shoot it, she used the blunt end of the pistol. And when people hear that, we don't have placements other than jail, they get worried. And then when they hear that Sununu Center, which is very limited in who you can send there, but it's scheduled to close in March of 2023, they get even more concerned. And so that was part of the conversation with the Bennington Police Chief and other leaders in Bennington that we did have a while back, and the state's attorney with Monica about this violent group. And I can't urge you enough. We have no power right now other than being legislators. We're not in session. But we've got to solve this problem right away for this small number. If we don't, we lose the confidence of the public that we know what we're doing with kids. And that I'm fearful that other kids, the 99% of the kids who are benefiting from the system, and some as messed up as it is, somehow they're benefiting, in my view. And I'm afraid we lose the public confidence in what we're doing, because it is those violent kids that the public is noticing. I don't know that we have much choice to keep going without the use of some combined effort of the Department of Corrections and Department of DCF. Back in the day of Woodside, there was an agreement, memorandum of understanding, that kids who were charged in adult court could be held at Woodside. And so you don't have that anymore, obviously. But I'm hopeful that sooner rather than later, and by sooner, I mean sometime in the next 15 days, we can solve this, because the what you described early on in your presentation about what's been going on in southern Vermont is spreading to to Chittenden County, spreading to other areas of the state. And I'm really fearful, not only for the safety of the public, but the safety of many of these kids who get involved in this behavior. So I really can't impress about how much concern I have for this. I don't know that you have any choice but to open a few beds in one of the correctional facilities that are specifically staffed and at least temporarily for kids who are acting out in a very violent manner.
I share your concern, and please know that. And we do work very closely. You are correct. We had an MOU with corrections. So if there was a youth charge as an adult, they could be placed at Woodside. Recognizing now that that's no longer an option, you know, in those small number of situations where we have had minors charged as an adult and needed to be lodged, you know, we do work closely with the Department of Corrections, and they have been able to create a sound and sight separation in a facility to provide services to those youth. And we are very involved with corrections in providing services and support to those youth while they are in that setting. You know, by way of having our clinical director there upon admission, working with the clinical team in corrections, getting outside partners in there to support the youth, depending on what their needs are, ensuring that aftercare planning is immediately happening so that once that youth is able to step down, that we have a plan in place and that we're working with that youth immediately. And so, you know, we have, been able to, move forward in that way, working with corrections to support those youth when that has happened. It's happened with a limited number of situations. Granted, it's not ideal. And our preference would always be to serve youth in the community. And as soon as we're able to do that, we'd like to do that. But recognizing there are situations where a secure placement is needed. And we continue to focus an immense amount of time and energy on this specific issue from DCF and AHS. And we are continuing to explore all options to try to move something forward as quickly as we can, Senator.
Appreciate that. I think I urge you to make this public, more public. And I realize that it may be uncomfortable, but I think
People need to know.
people need to know that we're at least attempting to deal with this crisis. I don't think it's a long-term thing. I do think we'll come out of this, that we'll find ways. I know one of the frustrations is that many of the kids, what you pointed out is the loss of long-term placement. Also, you didn't divide it up when you said you lost half your placements, but a lot of those are long-term, where kids who are in short-term programs are now held in short-term programs longer, which leads to their acting out because they don't know where they're going. And, you can hang out for a couple of weeks, but when it gets to be 45 days to 90 days hanging out, waiting to find out what's going to happen to you, it becomes more frustrating, particularly if you're 15 or 16 years old or 80.
Great. Teresa?
That's sort of a good segue, Senator, to my question is back on the residential capacity chart that you provided and recognizing that you have had a loss of residential capacity. What's your occupancy rate of the beds that you do have?
Currently, we have, now we're down, because some programs have closed or permanently taken some capacity offline during the pandemic. We are currently at a licensed capacity of 154 beds. 97 of those are open and being staffed and under operation. So we're at 63% of the post-pandemic licensed capacity. We're at 50% of the pre-pandemic licensed capacity.
Right, yes, I have that, Commissioner. That wasn't my question. I understand what your capacity is and that your capacity has been reduced. Are you utilizing all of those beds? Are you at 100%? Are all of those beds full right now?
Of the 97.
Most of them are full. It'd be a rare circumstance now, because we track this pretty closely, just given the stress in the system, so that as we're planning for youth that might need to step up to a system of care or step down, we monitor this pretty closely. And if there's an opening, we usually fill it pretty quickly.
Thank you.
That's exactly correct. I believe at this point we put out a bed board every evening, and we may have one bed now. So there really is not a lot of flex in our system, which is why we keep such a close eye on it.
I'm going to move this along because I want to hear from the state's attorney in Bennington. Erica Marthos is here. And I also want to hear from the Commissioner of Corrections, folks on what corrections can do to help here, if anything. So Erica, welcome. We did go over the situation a little bit that happened in Bennington, but I want to offer you opportunity and time to testify.
Thank you. So I really just have a pretty basic ask, and that's exactly what Senator Sears just said. Can we just immediately get some beds at one of the jails that are earmarked for this use, for youthful offenders, that we have met all of the public safety requirements in S224. So S224 sets out what population we should be talking about, right? So if someone is an offender that is charged with a particular offense, that we make some we take some consideration about essentially their danger to the public, and what we need to do to protect public safety. As it stands now, we have no place for the individuals in this demographic to be. And the concerning thing is the plan that's on the horizon, even when it's completed, is still not going to address all of the demographics. We have the Newberry and the Windham County place. Those still are not going to create a place for all of the different gender identity, gender at birth. We don't have a place. So that's what puts the state's attorney in a terrible position, because as most of you know, I have been a proponent of raise the age, and I think that there are certainly a lot of 18-year-olds in this state that could benefit from the assistance of DCF and being treated in the family court. However, the cases that are landing in that age range of late have been violent, they've been dangerous, and not necessarily individuals that I would say should be youthful offenders. We have a mechanism to sort those out. We have a hearing, we present evidence. The court can make the decision that that person will be treated as an adult in adult court. However, getting there takes a long time. And so, on a side note, that's a whole other process that I know will be coming up in this coming legislative session, where we can actually talk about what that process looks like. But in the meantime, our hands are completely tied. And I've had this conversation with Commissioner Brown. It's not that I think DCF's not doing their job. They certainly are. Frankly, when he had to think, or look at something to see if he had any, if he was at 100% capacity, I could have told you he's at 100% capacity, because they're always at 100% capacity. We just do not have enough placements. And so I really appreciate kind of the thought process that this needs to happen right away. And if that means doing something on a temporary basis, then that's what we need to do. It's not like we're creating something for some future scenario. We've had these scenarios have happened multiple times, repeatedly in different communities. And, sadly, particularly in Bennington, and we're getting a lot of pushback from the community. I do think that I appreciate that Senator Sears mentioned the fact that, I think I mentioned this the last time we talked about this, that the youth that are in the placements that we're putting truly dangerous youth in, they shouldn't, the kids at 204 or 206 or, Bennington School for Girls, wherever they are, they might be benefiting from that program. And, even after 22 years sitting here, I'm still convinced that we make a difference sometimes. And I have to keep telling myself that, but it's really disheartening when I think about the fact that sometimes we are taking individuals that are dangerous, violent individuals that just happen to fall within a certain age range, and we're placing them with kids that are otherwise gainfully engaged in treatment. I hope this is only a temporary situation, but regardless of whether it's temporary or not, we need to do something now, because somebody, God forbid it's a young child or a youth, somebody's going to get seriously hurt. And I'm not just like ringing bells. It's pretty scary. Like the level of violence, it's not just the presence of guns, it's the willingness to use them that has really changed in Bennington. So I would just urge DOC and DCF to really come up with, a room, a place, a wing. I think you've all heard me I know Commissioner Brown heard me talking at the last meeting I was at with him that we literally talked to the sheriff about, manning the holding cell in the courthouse and just putting a cot in there and having the violent youth that we were trying to house stay in the courthouse through the weekend, because otherwise we were looking at DCF having to come up with, what are they going to do? Put the youth in a foster home? I mean, it's nonsensical.
So Erica, I want to thank you. I know you're in the hot seat with all of this, but we do have the Commissioner of Corrections here, so we're going to continue the conversation. But I want to make sure, see if there's any committee members that have any questions.
I'm going to wait till after the commissioner.
Okay. So let's segue into the Commissioner of Corrections to see what options he can put on the table, if any.
Yeah.
And if you could identify yourself for the record, and I know that you brought someone with you as well who deals with classification facility issues.
Absolutely. So Josh, if you want to join us. So my name is Nick Dimmel. I'm the Commissioner of the Vermont Department of Corrections. As many of you know, nice to see you all again. And thanks for having me on such a simple and easy topic we should be able to solve in just a few minutes. Yeah, I find this to be an extraordinarily perplexing, multifaceted, vexing challenge that I would love to help you craft a solution. I'm not sure what that solution is. And usually I feel like I'm fairly good at finding them fairly quickly. I would preface, I guess, my comments by saying there is an option. I mean, if a youth is charged with a felony in the state of Vermont, there are options to get them to go to the correction system. We know that because we've done it nearly a dozen times this year. So the idea that there is no option at all, I think is not quite right, because we've done it many times. And we can continue to do that. We can create space, and we can flex our system to house youths. But that's going to come with some serious ramifications. And I think that we need to be really cognizant of that. There are logistical challenges in the Department of Corrections that will make this extraordinarily difficult, not the least of which is staffing. And we spent a good deal of time last week or 2 weeks ago talking about that. It's also worth highlighting, though, that corrections staff in the state of Vermont are not trained to handle youths. They have no training on the differences between uses of force. That they don't know, they're not trained on the mental, emotional, physical health states of youth and how that differs from adults. We don't have youth programming in our system. And none of our staff are trained that way. Could we flex to retrain them? Theoretically, yes, with programming perhaps from DCF or assistance from other organizations. But again, we turn back to the staffing issue. And that means we have to take staff offline from somewhere and something else has to give. The most likely place that we could do that is at Marble Valley in Rutland, but it's also the smallest facility with the least number of staff. And so if we took a lot of staff offline to go through training like this, it would create those challenges. I don't think that's the biggest problem. I think the biggest problem is, were we to create a space within the Department of Corrections that you would house youths who have been charged like we've been talking about, you would be asking us, the collective you, not the legislature, but the state of Vermont would be asking us to now run counter to all of the philosophy we've just spent years establishing. And so the legislature has asked us to really push youthful offenders out of the correction system. And we've worked very hard to do that and adjust to that reality. And then we would be turning back to say we need to bring them back into our system.
Just so that it's clear, we passed raise the age and youthful offender laws. We put in carve-outs for those age 16, 17, and 18 who committed what's called the Big 12 or charged with the Big 12 or convicted. We also allowed 14, thank you. So we also allowed youthful offender status for some of those kids if the judge so desired, which would allow dual custody of DOC and DCF. And the theory was we always had something at the top for those kids. Right now, we have nothing at the top. We don't have a Woodside. We don't have a Sununu. We don't have, and so I don't think it's against what we designed in the raise the age and the youthful offender laws. It's what has happened is we don't have the facilities that are needed to house that group that we said didn't belong with the other 95% or 99% or whatever it was. I just want to make that clear, because as you say that, and I understand the challenges, but it's either you or DCF. Somebody's got to take care of those kids. And where we're putting them now is not working. That's, I think, what at least my chief of police in Bennington and my state's attorney and some members of the DCF staff and others are telling me. So I don't think, and also, by the way, the hospital in Bennington is telling me this too. They're not the place to hold these kids.
Right.
They have staff getting assaulted, nurses. So I understand everything you're saying, Commissioner.
No, I appreciate your comments, Senator, and I certainly understand the burden we're all under to try to solve this. I will say, though, having now seen the fact patterns that underlie some of the crimes that we're talking about, and some of the folks who have ended up coming to our system, they may be, in many cases, they may be charged with a Big 12 crime, but the facts that underlie that are really challenging and aren't as straightforward as your traditional homicide that occurs between family members or a gang dispute. In many cases, they're victims themselves of a variety of other issues. And I think that's particularly true when we talk about youths. There are certainly victims across the correction system that also commit crimes and have been incarcerated for that. But I do think we need to be especially sensitive to this subset of individuals that we're asking to solve for. You had a question, Senator. I know Josh, I think, wanted to weigh in on something, so I'll pause and not take up too much of your time.
Listen, Woodside was built at a terrible time with a heinous crime, and those kids were placed there. And since that time, we've seen kids go through Woodside. Right now, we do not have that option. True, boom. And all the things that you were talking about in terms of workforce, support staff, all of those things are absolutely necessary for children, regardless of the crime they've committed. They aren't fully grown. And yes, they have trauma in their lives and so on. So, but that brings me to the place where we are currently in environmental court with Beckett, or with the facility.
Beckett.
And a part of the decision-making around that facility is staffing. And so having staff available, once it's built, we're going to have to hire staff. And I don't know, Senator, whether we have that built into the budget at this point, but it would.
It was in the budget that passed in 20.
Yeah.
Stephanie can correct me. There was
Yes,
money.
it is. We do have appropriations to pay not only for the facility, but for the ongoing operations of the facility on our budget.
Thank you, Commissioner Brown. I mean, that's very helpful. So there's a creative solution here, perhaps. Who knows? I'm not suggesting to fill Marble Valley up necessarily, but maybe there is a place where there are beds available, whether it's in the women's prison for women, for males, for whomever. But somehow we need to care for these people. And somehow having them in a secure facility with appropriate staffing is important. So I would be open to listening to some kind of agreement with hired staff that once this temporary process is completed, they would be eligible to move on to the facility. So I don't know if anybody's talked about that or not.
So it's real simple. You need a building.
You need a building, you need people.
Staff that's not DOC staff. That's what you need.
Yeah, so, but if we have a place and we have resources to hire staff, I just think this is just going to escalate. It's going to balloon. It's going to keep going. And unless we start to put the top on it.
So if I may, Senator.
Yeah. Could you just identify yourself?
Yes, Joshua Ruther, Director of Classification with the Department of Corrections. There is, as Senator Sears referenced, a mechanism under law, two, in fact, mechanisms to place emerging adults with Department of Corrections. Either being charged with a Big 12 offense starts them with us, or a felony offense can start in family court but be moved to criminal. Both of those mechanisms are in place to place folks with corrections. As much as we have repeatedly expressed concern around that mission, we have never said no to those kids. We have never said, with the exception of the one where we had a question of legality, we have housed those. We have continued to. So as the commissioner is saying, that option remains on the table. If an emerging adult is charged that way this evening, Department of Corrections will house them. And we can continue to do that. Concerns notwithstanding regarding that we've never turned those folks away.
So my question on something like this, knowing your staffing issues and knowing the training issue, by housing a youth with those circumstances, does that put DOC at risk, liability, when you don't have properly trained staff?
Well, I'm a lawyer, but I'm not our lawyer. And so I'd probably defer to her to answer that question on liability. But I would assume the answer is yes. I mean, I think the other facet of this is space. And as everybody in this committee is well aware, the Department of Corrections isn't flush in space either. So we talk about Marble Valley a lot because it's the easiest, I think, for us to readjust for the needs that we could meet youth with. But what we would use is the closed custody space there. And then that closed custody space becomes unavailable. And those closed custody individuals have to be moved to other facilities. And closed custody space in the system is already at a premium. And so, I mean, I guess the way I think about this, to take one step back, is first we answer the question of should we do it? Philosophically, should we do it under law, et cetera? And if we can get through that to say, yes, we should, DOC should take them on, then it's a can we do it? And that's where we get to the staffing drawbacks. That's where we get to the space limitations. There are ramifications, even if it is another provider providing the staffing services, there are federal laws that dictate how we manage juveniles in an incarcerated setting. And so that has blowback, that has second, third order effects on the rest of the system. But to Josh's point, I mean, at the end of the day, we raise these things for your consideration, but we continue to do the needful when it happens. And we've done that, I think, about a dozen times this year, and we'll continue to do it. Now, the only other thing I would put on the table as kind of a logistics matter is, even if we did all this and separated out a piece of Marble Valley or some other facility, that really only solves for the male population. And if we had a juvenile female, which we did this year,
Then you get back.
the world flips on its head, because our female facility is well known, is small and difficult to reconfigure on short notice. And it's the only facility where we reasonably can house for any extended period of time a female, whether she be a juvenile or otherwise. And there's a body of federal law around that as well. So theoretically, this is possible, but it would have ramifications. And if ultimately that's the decision that the state as a whole makes, then certainly we're very good at soldiering up and getting it done. But I think there's a lot of variables to consider as we make those decisions.
Well, I must say, I find it interesting, there was more pushback when the female teen was held at the women's facility than when you've held the male.
Yes.
Folks. That seems to be, for the public, okay for the males, but not for the females.
Well,
And that, I'm concerned on both.
yeah, I hear you.
I'd be concerned on both.
Yep. Yeah, but our problem is now, facility is non-existent, nothing to be seen for several months, if not years. You can create space within DOC by sending people out of state. And that's something that nobody wants to do. But it may be necessary to do. The question for me is if we go the route of reconfiguring a unit in Marble Valley, what's the demand from DCF? Is it going to sit empty? Is it going to be 50% full?
I see.
And I'm sure that you probably, I don't know if you've had that conversation with Commissioner Brown or not, but it's something that we need to think about, because hearing from Senator Sears and Attorney Marthage, this is an immediate need now today, and it's not going to go away. And I don't see any way of solving it, because we have drug our feet in the legislature on building a new facility.
Some of us have.
Some of us have. So we share, the legislature has to share some responsibility in this. And if part of the responsibility of sharing it is moving people up the state, we'll have to take the hit on that too. And I know it's been a goal to reduce our out-of-state population, and corrections has done a great job doing that, but we may have to increase it. If you have the right individuals that could go out of state.
And that's
an issue.
That's right. So today, I think there's approximately 30 individuals in the state of Vermont who could theoretically be eligible under our criteria to move out of state. We're not in the process of moving anybody out of state. We've brought a whole litany of folks back, which is good, I think, on the whole. That number is not at a scale in which it meaningfully changes the situation for DOC, which, is further reason not to do it. But you're right. I mean, that is a potential relief valve, and which is the reason that the state has the contract.
Temporarily fix facility problem by creating some vacancy, by possibly getting some people out of state. And now the problem becomes, how do you staff it? And that's above my pay grade.
Mine too, I think.
But, a conversation would have to be had with Commissioner Brown. How do you staff that, and how do you retrain? Obviously, we'll have to retrain some of your folks to be there. And what's the time frame? Should we start tomorrow?
Right. I mean, I'll just add, I know I just keep adding complexities to this, and this is what my day is like every day. But the 30 individuals that I kind of discussed as being eligible for going to the out-of-state facility are not all at Marble Valley. I couldn't tell you how many are, probably a very small number. Yeah, because we use that largely as a detention facility at this point, which means we would have to grab them from somewhere else, move folks out of Marble Valley, and then we begin to run into this concern about mixing risk levels. And so we're very purposeful about where we house people based on their risks, their needs, and their responsivity. And there's a concern about that as they relate to juveniles, but it would also be a concern if we begin to start rejiggering the whole system to make a small change. So it's not that, again, it can't be done.
Small change for space, but it's not a small change for the problem. That's why I brought Josh with me today.
Yeah, I bring the smart people everywhere I go.
So I know Erica wants to weigh in here, so go ahead, Erica.
Yes, thank you. The first thing I'm going to say is, so I'm a lawyer that's been doing this for 22 years. And I can tell you that the processes that we're talking about, Big 12, listed offenses, transferring youthful offender, those all take time. And they take a ton of time in the court. Everyone is entitled to file motions, respond, it gets scheduled. There's testimony hearing. What I'm not hearing is a proposed solution to a problem that needs a solution 6 months ago by the agencies that are responsible for housing these individuals we're talking about. The statute's plain. It's already been laid out, S-224. We already know which kids we're talking about, which youth we are talking about. It's in S-224. Once the state has a kid that falls into that, we need a place to put that individual. What I'm hearing is these youth are too violent for DOC or DCF. They're not violent enough. They're youth. And so DOC is not trained to deal with them. I've been doing this long enough so that I don't want to offend anybody, but I'm also really losing my patience with these kind of issues. Like, just come up with a couple of beds somewhere. And that may sound flip, but it's not flip when I'm the one taking phone calls, 6 and 8 phone calls a night, trying to figure out where to put someone who is dangerous. And I have local DCF workers that are saying, are you kidding me? I need to find a place for this person to be. It's ludicrous. Like, this just needs to happen. Seriously, take a couple of beds. I don't care. You don't need to ship 30 people down south. Ship 2 people. Make a bed. Yes, it may sit empty sometimes, but you know what? You need that one bed available. And honestly, I don't mean to be disrespectful, but I really at the end of my rope. That's why I struggle with whether to even testify about these things anymore, because it really is something that just needs to happen. Senator Sears couldn't be more right. We are having dangerous kids in our system exposing other kids. If you ask me, someone who has met the standard in S224, do I want to put that person with a 15-year-old that's at 206 for an unlawful mischief? Or do I want to put them at the jail? I know where I want to put them. The law says where I need to put them. And that's in a facility that's not exposing them to youth that are there for non-Big 12 offenses. And that's what we're stuck with right now. So, you know, we don't need to build a facility and come up with a whole new, you know, army of people to house it. We need a couple of people. We need a couple of beds. Even one bed is better than what we have now. We need a place that the court can look to. And I know Commissioner Brown is aware of this. We had an issue where I was relatively sure I was going to have to file a motion to enforce for one of the youth that showed up at the jail with a minimus to be held. And we were being told that the jail wouldn't take them on a Friday afternoon. So we need to do something, and we need to do something like yesterday, because any day I'm going to have another one of these cases, and it's not just my county, it's every county. We're all being exposed to this different level of violence in youth that we haven't seen before. We didn't plan for it, but it's here.
I appreciate this, Erica. Wish we had a silver bullet.
I will go back to my suggestion about beginning to look for staff who can support these kids regardless of the level of violence that they have committed and crimes they've committed. And to, if there are 2 beds available and they're in those beds, then having appropriate staff is also important.
So
they're not yet adults.
Right.
They're still in juvenile court. Or they might be, unless they're really up there. So then we also have.
It's worth remembering, Senator.
Can we begin to look at a creative way of hiring folks to help these people, to take care of these people when they're incarcerated, and then as a new facility is built, to move both the population, the support group, and workforce. I don't know whether that's possible.
So we're looking, what I'm hearing, a few beds at a correctional facility and looking for staff that is not DOC staff to supervise. Is that a possibility?
I think we need to talk to the Attorney General in the council's office, but unless they're charged as an adult or charged with a Big 12 crime in criminal court in the state of Vermont, there is no legal mechanism for them to be held in the Department of Corrections. And I recognize that potentially you could use some space in the Department of Corrections, but I think that there would be a strong legal argument that that would still be constitute a custody of the Commissioner of Corrections.
My understanding was we're talking about 14 to 18-year-olds who are charged or convicted with one of the Big 12 offenses. And not, whether the charge is too high or whatever, deal with that all the time.
Sure.
But we're not talking about kids charged as either a youthful offender or charged as a delinquent.
I see.
That's still DCF's problem. I just want to reiterate, I wrote down what Erica said, and I thought it really hit home to me. It's not just the presence of guns, it's the willingness to use them that's changed.
Yeah.
And I think we have to recognize that. I thought that was I'll probably take credit for it when I use it someday, but I'll try to attribute it to you, Erica.
But that's how our culture is.
So there aren't any of those, residential programs that have, shut down or reduced capacity that we could potentially use as sites.
They may not be secure enough. We don't know what's secure level.
I think all that's left is staff security.
And we may need more physical buildings secure.
So
Which is-
Representative Wood, to your point, we've certainly been looking for a facility, and then there would be modifications that would need to be made to make it hardware secure. But I'm afraid what we'll run into is what we run into Newberry and what we started to run into this past session when Windsor was talked about, which is, we run into permitting and local opposition to the siting of these type of facilities. And I think that needs to be, that's just something we need to acknowledge as well. That could slow this process down.
For this.
Windsor didn't pan out in any way. You still think that there would be a pushback in that community, even though it has been a facility for so long?
What facility?
Windsor.
That has been closed for what, 7 years?
As a facility, we did do a site visit this winter, DCF and its team with BGS and to evaluate that facility. And, I think to Representative Emmons' point, it's quite dated.
It's dated.
And you would almost need to raise sections of it and start anew. And then you run into, and then there were there was, let's just say, some local opposition already surfacing during those initial conversations.
I would just tag on being familiar with that site. That was designed for our lowest security individuals, most of whom were nonviolent or minimum custody. So I think even from a site secure, it wouldn't necessarily be what we would consider an appropriate site secure for folks pending violent charges. We didn't use it that way.
And to add a little more complexity to that, we did put money in the capital bill to start taking down the racer wire. So we can start
marijuana there.
So we can start marketing the property somehow. But there's a lot of land there that you could build.
Good farmland too, right?
Good farmland, and there's a wildlife management area there that could use people power to start managing, clearing paths and trails.
So I will add for the committee, State's Attorney Martha touched on this a little bit, that, Newberry doesn't solve all of the needs of the state of Vermont. And the legislature asked us to provide a report in December with a plan to meet that broader array of needs that have been identified. And we are working on that plan. And we'll be submitting that in December, which would be a facility that would have the flexibility to meet the varying needs of the different populations. And that will need, be proposed as most likely a new facility and, and a plan to move that forward. So that is in the works, but that's a longer term solution, not a short term solution, what we're talking here. But I do want to acknowledge that there are other needs, and we are working to address those with this plan that we'll be submitting in December to the legislature.
Problem is, we need a short-term solution, and short-term is not a few months. Short-term is a couple of years. Because even if you're going to build something, it's going to be at least a couple of years.
I agree. I just wanted to add in too, in terms of we're looking at sort of a short term, if we were able to meet something for the immediate need, working with DOC, and in terms of a midterm, I have staff actually in Pennsylvania now looking at a program that does treatment-based, trauma-informed, more secure facilities in Pennsylvania, talking to them, perhaps we can use them now that we're not able to work with Sununu, and also discuss any future possibilities with them in terms of our longer term goal of having our own secure facility. And we're continuing to look at other possibilities as well. It's just that many states, like New Hampshire most recently, are beginning to close down these secure facilities, and it's making it more difficult for us to find someone to help us in this regard.
So we've got a tie up here. We got one more item that we really have to deal with. We have to hear from DOC on this next item. Where do we go from here? This issue. Just kind of keep leaving it dangling?
No.
Or do we direct DOC and DCS to start knocking heads over the next few days and figure out?
ask them to come back, and then we don't have a meeting scheduled for a while, but maybe the plus, just remotely, I think. State Attorney Martha just pointed out that they really don't have any choice. If somebody is sent there, they have to take them if they're an adult, charged as an adult. So it'd be better to plan something, I would think, than to take them by surprise at 11 o'clock on Friday night that this 17-year-old is arriving at your facility.
And we do that, sir. I mean,
but I think it would be better to have something planned out so that, because I don't think this is going to go away for at least 6 to 12 months. I think it's time to start planning on it so that, you know, State Attorney Martha is not the only one that's going to be doing this. So there are others who are, and I think this situation is going to just continue to grow, unfortunately. You know, we've seen cases from particularly Springfield, I think, South Burlington.
We sent him over to Bennington.
Bennington? No, Bennington has had its share, but I don't think this is something that's going away. We get our news from the Troy, Albany, Schenectady area. The same thing is going on there. It's not just Vermont that has these 16 and 17-year-olds acting out in this manner. The gun violence is going on all around us. It's just our borders that, you know, maybe we need a border wall.
So, but I think part of the conversation needs to be is once you open up a space, how do we take care of these? How do we, is it going to be DCF personnel within your facility? Is it going to be your personnel being retrained to take care of these people? And I think that's as big a nut to crack as finding a space, because you just said, I can find you space.
I can't, I mean.
They're going to be incarcerated for a long time, even pre-trial.
Maybe not. I mean, I think there's people, especially kids, tend to settle down, believe it or not.
You make a valid point there, Senator. That's our experience, that once you get a youth stabilized and engaged, that very quickly you can transition them to lower levels of care pretty quickly and engage those youth and reduce the risk of you know, that they might have posed before you started working with them.
So in my experience in the last almost a year, when we've had juveniles come in, they come into the custody of the Department of Corrections. And so they're under control by corrections staff. Now, DCF has done an excellent job of bringing in their team and working with folks. But at the end of the day, the people who are there with them overnight are corrections officers. And I would expect, you know, unless we have some other arrangement worked out, that would continue. And I would also just remind you, we have an adult correction system in the state of Vermont that is oversubscribed. It's about 110% of what it should be. And now we're possibly being asked to carve out another thing to take on.
I want to put it a different way, Commissioner. You're not being asked. You don't have much choice. Do you want to plan for this?
Sure.
Or do you want the courts to tell you you're going to take Johnny Jones tonight?
And
that's, I think that's what's going to happen. I don't think you're going to, it's not something that one will wake up with and say, oh, I just think it's better to have a plan together so that you're not taken by surprise, that you can deal with that kid, that you have some protocols with DCF or whatever. That's,
I understand.
I'm seeing it.
So what if I give you 10 days and you have to report back between you and the commissioner of DCF and the commissioner of DOC, come back to us, and it would be reporting to Senator Sears and myself on your plan going forward.
Happy to do that.
Because we can't do it as a whole committee, because then we've got to have another committee meeting. But if you could at least do it to the chair and vice chair of this committee in 10 days. Of course, that brings it right up to Columbus Day or Indigenous Day weekend. I'm trying to figure that one out. The Thursday before the weekend.
Thursday before the weekend. Oh,
'cause
Columbus
it's a
Day.
Indigenous Day.
Indigenous.
Oh, God.
Columbus.
There I go being old.
Yeah, Indigenous Day.
Indigenous Day.
That Thursday prior, I don't have the date in front of me, but between you two commissioners, go figure it out and come back.
Happy to do that.
And we'll do a Teams meeting or something.
And then there's nothing to prevent us from having Ben join us so that it can be reported back to the
Right,
full committee.
then you can report back to us. We gotta move on here. But Eric,
I appreciate it. It's a difficult situation.
It's tough, and-
No, there's no clear answer, you know, it's gonna require everybody doing something they don't necessarily want to do.
well, we've got to step up to the plate.
Including us.
We at some point are gonna have to have a state-run facility.
That's,
So I want to thank you, Erica, for weighing in. This is very helpful. I want to thank the folks from DCF for joining us, and we will see you in a week, a couple days, the Thursday prior to Indigenous Day weekend.
Thank you.
I don't have the date, but we'll do that. So let's quickly, we got one more item on our agenda. We're going to be dealing with this a little bit more in depth, but there is a proposal that the Commissioner of Corrections wants to put on the table. We had in our Justice Reinvestment 2, if you remember, those dollars are funded by the savings in out-of-state beds. And we have going into the FY23 budget from the FY22 bed savings, the budget bed savings of about 1.9 million. We need to make a recommendation to the legislature on how those dollars are to be expended in the FY23 budget. So that's the bigger picture that we're going to have to deal with. There is one little subset of that 1.9 million that the commissioner has a proposal for. But there's some logistical steps that we will have to deal with. So I'm going to turn it over to the commissioner.
It's for a youth facility.
Stop it.
that's not even funny.
No, I think this is, turning the page here. I think this is actually a good news story for the state. So thank you, Representative. We've struggled in the past on how to spend the justice reinvestment money because there's some parameters to it. It's one-time money, which makes it difficult. And we don't know year over year exactly what the carryover will be from the out-of-state bed savings. But one of the areas that the legislature asked us a lot about last year was improvements to our offender management system. And so that's essentially the computer backbone to the Department of Corrections. It's clunky and challenging to use. It's especially challenging to change or manipulate. But there is a piece of technology that's called an intelligence layer that we could set on the top of that. And basically it uses APIs, now I've run out of technology, runway, so bear with me, but basically reaches down into the OMS database and pulls data out, uses it, analyzes it, and gives us products. There's a variety of different ways we could use it, but the key pieces that are important to me are case management and the case management of an individual from when they first come into the system through their release planning and then when they're out in the community. It creates a data-driven risk needs assessment. And so that's the risk to recidivate, the need for programming, all of that is informed by our risk needs assessment. We do that right now in a very manual way. And it's really dependent on the department to come up with the output there. But this system would grab data from the incarcerated individual's file and analyze it and provide additional information. Basically, the way I think about it is if DOC were to come up with 10 data points about an individual's risk, a system like this could come up with 1,000, 10,000, 1 million data points that would help make more refined, better risk needs assessments for the individual. And so ultimately, this is a piece of technology that we'd be interested in pursuing. But before we do that, we'd like to do a study of our current offender management system and how this would interact with it so that we could understand what pieces of a tool like this we would want. We think that the cost for that would be somewhere around $200,000 to $250,000 in that range. And if we were to get access to this money now and put out an RFP and start this study, we think we could have the results before or around when the legislature came back into session so that we could present a broader plan in the January session. And so I wanted to bring this to you all and happy to discuss any piece of it. But I think it would be really revolutionary in a lot of ways and ties directly to the JRI work that we're trying to do as a department, because it will give us better risk needs assessments to set up programming and then create very seamless case management planning for individuals as they go out into the communities. And we can connect this with our community-based providers. They could have input into the program as well as eventually, what we could grow to is having these systems set up in other state departments and we could connect them all. And so there'd be more seamless transfer of case. Now, I know I might be blowing minds here.
We have IT.
Oh, yeah.
Oh, yeah. We get all sorts of promises about IT.
Yeah.
Right. Fair enough. So I'm only talking about DOC, but if somebody else wanted to tag on at some point, there could be, some of this more seamless case management across, I think, especially, I think of DMH, I think of Dale and DCF, because we know that the clients that we serve in DOC are also served by these other departments.
So the request is, for what I'm hearing, for a study to see if it's possible to put another Lego on top of our current offender management system to start providing the case planning electronically.
That's right.
I see it as a Lego.
Yep. No, that's it. I think that's exactly right.
So the thinking is you would need up to 250,000 out of the 1.9, but you want to have that within the FY22 budget. Language that was in the appropriations bill for these out-of-state bed savings to be invested in JR2 is for FY23. So we'd have to make an agreement that, yes, we're going to go just with the FY22. That's number one. Number two, we can't say the final go-ahead. We can make a recommendation. The only committee that can operate and make any decisions off session is the Joint Fiscal Committee. Joint Fiscal Committee is meeting the beginning of November. We could make a recommendation to the Joint Fiscal Committee to release up to 250,000 from the 1.9 million bed savings for FY22 for this particular study. So that's what's before us.
So I just have a logistical question. So
It's complicated.
Yeah, because it's FY22, I'm just trying to think. So the department didn't get any, you could have, I guess, but maybe not because this is JRI money.
The way it operates is in the budget for FY22, they put X amount for out-of-state beds.
Yeah. And
based on certain bed numbers.
Right,
they don't know the numbers of that until the fiscal year ends.
Right. Yeah, I understand all that, but I also know there's I'll ask Stephanie this, but there is a mechanism, in state government to be able to utilize FY22 funds in 23 without a JFO approval.
But this is not.
But this is justice reinvestment money, so that's why it might be different, is what my point is.
Stephanie.
So I just wanted to point out that actually state fiscal year 22 is closed. It closed on June 30th. Right. And it might be helpful if we put up the language around the carry forward of out-of-state beds. Would that be helpful?
That would be helpful. I've got it here that I can read it. Either way.
Stephanie's got it, it looks like.
I do have it. Let me
read it while you're figuring it out. In fiscal year 22, which has already ended,
in our,
Any unexpended funds for correctional services out-of-state beds shall be carried forward to fiscal year 2023.
right,
So the savings in the FY '22 budget is then used in the FY '23 budget.
So these monies are already appropriated. There's no other action needed except what's described
We are in FY
in
'23.
B.
that's what I'm saying.
I keep forgetting that.
Yeah, that's what I was getting at. It's like, it's already, we don't need JFO approval because it's already been
No.
No,
appropriated.
we
No.
need this committee's approval.
Right, that's my understanding.
Yeah,
But doesn't
This
it,
committee's approval and then notification to other committees.
but can we actually appropriate carry forward money?
Not appropriate.
Money, the carry forward money is already appropriated. It's just carried forward.
it's good.
Spending,
We're just saying
spend it.
spend it. It's there.
Appropriate, so it's spending.
It's already
Yeah.
appropriated.
It's already
Spend it, We can spend it.
A buzzkill question.
And we can
You're a what?
decide what's the right way to spend it.
It says community-based programs.
Right.
That's
not.
my question.
So I wonder, and this, you're funding a study, you're not buying anything and anything else. I'm wondering if we should ask ADS to weigh in on this.
That was my question.
And happy to do that. The OMS system is housed within DOC, and while they have many inputs into that.
But we formed this whole Agency of Digital Services to stop departments and other agencies buying their own stuff because it was out of control. And I'm a little hesitant to say yes until I hear from ADS. Say, yeah, this is a great idea, or this is a crappy idea. And I know you're probably you want to get this thing on rolling, but in the interest of not opening my mouth and saying something about this, I really think that we need some guidance from the Agency of Digital Services. Not that I don't think it's a good idea. I've been on the end that's been burned by this before, and I'm not willing to go back there anytime soon. By a great idea that just didn't work for the rest of the state government. And I like your idea of sharing this with other agencies. I think that's a great idea, especially with Human Services, with DCF and their other clients. But I'm just kind of skeptical, Commissioner.
Fair enough.
Not that your knowledge, I'm just skeptical of spending $250,000 where I don't know where I'm going. And yeah, that's all.
I'm not averse in any way to having ADS weigh in. Certainly they are the technological experts for the state. I think and maybe this runs counter to what you just said, but the difference between DOC is that there is no other state department that has a management system that's structured in the way that ours is. And it's deeply flawed, don't get me wrong. But this would be impacting only that system within our department. And so I don't think it would have the reverberation through the state that some other kind of massive technology projects have had. But that's all to say, I understand your point and I'm not averse to that.
So I understood you to say, though, that this is to study your current system and I guess maybe pull out what you would expect from this add-on.
Yeah, so it's to study whether we can and what we would want to attach to our system to create this kind of continuum of care as individuals move to the community and get them connected with the right supports in the community.
Okay, all right. And I guess I'm with Butch on this, though.
We've been burned.
With that, from what my understanding is, everybody, including corrections, before they're taking on a technology project, they're supposed to be inquiring of and facilitating that through ADS. And so you're not sitting there saying, oh, well, we've talked to ADS and they're okay with this. So I'm not sure if you've talked to ADS at all or not.
We have ADS staff embedded in the Department of Corrections.
Yeah.
They're involved in some of these presentations. We've not asked ADS leadership whether it's something they support, but it's certainly something we could talk to them about.
It's the supporting part saying, yeah, this is something that we should look at.
So two things. One, it would be great to get something in writing that demonstrates is the ask and what the 250,000 goes for. And then two, the ADS opinion about whether that's the best way to proceed. I think that's all. It would be helpful to have that.
Yep.
Sounds like a great idea, but.
To the other committee.
I've got a graveyard full of great ideas.
Yeah, we don't want to throw out something that might work, right?
So that's, sorry.
No, go ahead.
It's certainly something that we'd be happy to present on and have ADS weigh in on. I'm not sure when the next meeting is,
Our
but
next meeting is the end of October, is it 25th of October, something around there,
I've got 20, well, that's
20
today.
something of October,
I got a 25 October.
25th of October.
That's to make it right, but I've got a 25 October.
My experience, I keep going back to a visit years ago at I think it was in Springfield, but it doesn't matter which facility. And I asked the vendor, well, what's your case
Yeah, and
plan?
they didn't know.
And they didn't know they had a case
Right.
plan.
That
So,
was in Springfield.
anything we can do to improve.
Yeah, they didn't have a clue that they had a case. So could you reach out between now and our next meeting, October 25th, to ADS? And come back and report to, I don't think we're adverse per se. I think that there's more questions and give us, and then also at our next meeting in October, we can talk about the remaining 1.625 million, because we're going to have to make recommendations on that as well.
Well, and I will leave it up to the chair and vice chair to interpret community-based programs.
Well, I go back to what the Council of State Governments said. One of their recommendations was that DOC needs to upgrade their IT systems for data collection, so it helps the whole JR2 process.
Yeah, I don't disagree with that.
That's what I go back
I'm just reading the plain language of the big bill, and that's.
Yeah,
that's what it says.
It may be a bit of a stretch, but it would help them working with treatment partners and et cetera.
Continuum of care, I heard that.
one of the other major recommendations of the Council on State Governments, though, was that we move away from all the paper systems that we have because they're horrendous and they don't serve the needs of the individuals.
But the key is that these case plans are done electronically, that then your field office folks have them and can coordinate with the offender.
And community providers would have access to put inputs into that system as well.
Right.
And by meeting the 25th, we beat the next meeting of joint fiscal.
And we're not going to need joint fiscal because this is only
Definitely put
approval.
up there.
Okay, so we
It's
can
our
just say by.
approval and we have to relay that to those respective committees. I just, it's this appropriations committee, I don't know.
In support of Justice Reinvestment 2 initiatives. So.
I mean, just to weigh in a little bit, I mean, when you see sort of how the budget adjustment bill, the language changed, it's community-based programs in support of JR. So there is sort of that common thread of language between all of the various versions. So I think that a reasonable interpretation could be that if this is a community-based program in support of it, then it's something that the Justice Oversight Committee can endorse, for lack of a better term. I always try to qualify that a little bit, but just looking at the language as it's presented right now, I think it's a reasonable interpretation of it.
And we already have a line item for their offender management system. Because we put in 60,000.
I believe. And that was a demand signal from the legislature last year that, hey, could we invest more of last year's recapture? And we couldn't because it's just too complicated of a system to change.
Well, I don't think there's a problem with your idea. I think the problem is, to me, it's just the process.
Yeah. So we're happy to bring a presentation in and have coordinated with ADS.
And then we'll figure out something for next week on Thursday.
Okay.
With Commissioner Brown.
If I may, I just wanted to point your attention to the last part of where we added a new sub C around these monies when you're talking about them.
Okay.
And that was the direction that the conference committee on the budget had from your committees, Representative Emmons, about making these reinvestments more permanent in the budget. So the intent is to actually, even though in the past it's been one-time money, but the new sub C intent language or directive language, it's not intent, it asks the Department of Corrections to build in that same amount of roughly 1.9 million into the 24 budget on a permanent basis for the same purpose and same amount. Now, some of these might be one-time items, and so it wouldn't be the same purpose, but the idea was to make the justice reinvest, the out-of-state bed savings a more permanent ongoing investment in justice reinvestment too. And that's what you see in the big bill for this year, effective in the C section. So it's effective to the 22 money.
It's helpful, Stephanie, because we did that because what we were seeing when we were asked to give our recommendations for that 717,000, we were picking up that DOC wanted to really go down the path of doing it more for one time than an ongoing budget expenditure. That was the base budget. So that's why we put in this language.
And that's what would make the roughly 1.9 ongoing, because it's a directive to the corrections to include that in their 24 budget.
Right.
In the justice reinvestment line.
Right. And that's why we also wanted to have a line item for justice reinvestment too, so that we knew that it was base funding. And we weren't going to lose it year to year. And anything that was added would be added to that base funding. So we're kind of carving out a little problem here with the 250.
It's a solvable problem in the budget adjustment. It's in the bigger question is whether or not this committee approves it based on your ADS discussion in the next go round.
Correct. Right. So this is helpful, Stephanie. Thank you for bringing that up. Anything else before it's 4 o'clock?
Anything else before you're here by yourself?
No, I'm going home. I've had chimney work done today, so I don't know how that's going. I'm a little nervous. Anything else before we adjourn? And we are back here in October 25th. We'll check back with the committee after Senator Sears and I speak with the two commissioners of emergency housing, so to speak, or juvenile placements. And we'll work on an agenda for October 25th. And committee members, you have thoughts, please connect with both Senator Sears and myself, and we'll work up an agenda. So with that, thank you folks for being on YouTube with us, and committee members who zoomed in. We really appreciate it. So we are adjourning for the day, and see you all in October.
Thank you, Madam Chair.
Thank you. So Charlene, I'm thinking you're going to take us off YouTube.
I certainly will.
Okay, thank you.
Charlene.
Was that Peggy?
No,
No, Charlotte.
That was Charlene.